Greg Brockman took the stand and read his own diary to a jury. Today, the fight is over whether the judge should have let anyone hear it. This is Musk v. Altman Daily. Today, we're doing an explainer. The two-step test a judge runs before a private journal counts as evidence instead of theater.
A co-founder reading his feelings to 12 strangers under oath. Yeah, I've got questions. Let's start with why that's even allowed. Okay, so Greg Brockman is sitting in a federal courtroom reading his personal journal out loud to a jury. How does a judge even allow that? What's the legal logic that turns someone's private diary into fair game?
Judges usually run a two-step test for evidence like this. Step 1. Is it relevant? Meaning, does it actually tend to prove or disprove something the case turns on? Step 2. Even if it is relevant, does the risk of unfair prejudice substantially outweigh its probative value? That second question is the balancing gate. And under federal evidence rules, Florida's code frames it the same way, the bar for keeping evidence out is pretty high. The evidence has to be more unfairly prejudicial than it is genuinely useful. In this case, Musk's team says OpenAI abandoned its nonprofit mission to personally enrich its leaders, including Brockman. His journal, which he's been keeping since 2010 per reporting from Times of India, goes directly to his state of mind and intentions around the company's founding and restructuring. Exactly the factual questions the jury has to resolve. So it clears the relevance hurdle. And Brockman himself told the court, per Ars Technica, that he's not ashamed of the entries. He just finds it very painful. A judge can be sympathetic to that and still let the material in, because personal discomfort isn't the same as unfair prejudice under the legal standard.
So if the embarrassment factor alone isn't enough to block it, is there anything that could have kept those diary entries out?
The strongest argument would have been privilege. Conversations with a lawyer or therapist carry special legal protections, but as Axios reported, conversations with a chatbot do not. And courts are increasingly treating those as fully discoverable. A private journal doesn't carry that kind of privilege either, unless it was somehow shared within a protected relationship. So for executives, the warning is pretty blunt. Digital records and personal notes are becoming primary weapons in high-stakes tech litigation. What they write for themselves today could be read to a jury tomorrow.
If you're tracking the power struggles shaping AI, try Anthropic Pentagon Watch. A daily briefing on Anthropic's fight with the DoD over Claude, military AI use, autonomous weapons, and AI procurement blacklisting. Find it wherever you listen to podcasts. You'll find links to every story we covered today in the show notes. If one of them stuck with you, they're there for a closer read. That's Musk v. Altman Daily for today. This is a Lantern podcast.